Hello, good morning, everybody. This is Dr. K Kapoor, former professor, IMI, New Delhi. In the last lecture, I believe the fifth one in the series, we had recorded a talk on, rather, I had recorded a talk on essential requirements of a valid offer. Continuing you know, with the essentials of a valid offer and a few more aspects relating to offer, I am recording another talk today, a brief talk today. So, special terms in a contract or special terms of an offer. Many a time when you enter into a contract, you find that there is a mention in the offer terms and conditions apply. You might have noticed this pretty often in the advertisements that appear in the newspapers. And sometimes those terms and conditions, they are either printed in such a small font that you probably cannot read them without a magnifying glass. And at other times, they just mention subject to terms and conditions or terms and conditions apply. And now you keep on researching that where are those terms and conditions. They are not mentioned anywhere. So the whole issue is, are you bound by these terms and conditions which might be limiting the liability of the advertiser, the person making the offer? Likewise, I am very sure many of you would have been giving your clothes for dry cleaning, or you would have been sending your parcels through couriers. Have you ever noticed that on the back side of the dry cleaner's receipt or on the courier's receipt's back, there are certain terms and conditions? Now, they particularly, besides other things, limit the liability of the dry cleaner or that of the courier in case of loss. So, the whole issue is that, are you really bound by those terms and conditions? That is the basic issue. So, here, let me please tell you that the law on the point is a pretty settled one, and we have case laws on the point which suggest, number one, that if the person had actually read these terms and conditions and understood them, he will certainly be bound by the same. There are no two opinions about it. The problem arises where a person claims having not seen these terms and conditions, or says that the terms and conditions were written, say for instance, in a language which he did not understand, which was foreign to him. Supposing if a person from Punjab goes to Tamil Nadu and gives his clothes for dry cleaning. The receipt that he might get might well be in a Tamil, which he may not understand. So the question is, will he be bound by those terms and conditions? Even if he knew that there were certain terms and conditions on the back of that dry cleaner's receipts. These are the issues which we must find answer to. So the first thing I have already told you is that where he admits that he had read those terms and conditions and understood the same, he will definitely be bound. But where, say for instance, as in the case of Parker versus Southeastern Railway Company, a very famous English case on this subject, the front side of the cloakroom receipt, the gentleman had deposited certain baggage in the cloakroom of a railway company and was given a receipt against it. So the receipt on the face of it mentioned for conditions C back, which he had actually failed to. He just took the receipt, folded it, and put it in his purse. So here the court held that the very fact that the attention of the party had been drawn to the fact that there are certain terms and conditions, he ought to have read the same. If he failed to, he will be bound by the same. But in another case, the case once again is a very popular English case, Henderson versus Stevenson. A person was traveling from Dublin to Whitehaven, and he had some luggage which he had deposited with that shipping company. He was duly given a receipt, and there were printed certain terms and conditions on the back of the receipt. But he claimed he never was made aware of those terms and conditions, and there were no words on the face of the receipt either, drawing his attention to the fact that there were certain special terms and conditions limiting the liability of the shipping company. He was held as not bound by those terms and conditions. There have been a lot of cases in India against the courier companies, against the dry cleaners. These courier companies, dry cleaner companies have inevitably been limiting their liability to a certain amount. Say, for instance, most of the courier companies that unless the parcel has been insured against, they limit their liability to just 100 rupees. Even the very well-known brands operating in this particular area limit their liability to just 100 rupees. And in all the cases that went before the courts, the court held this limit of rupees 100 to be justified, and the only compensation that could be claimed by the sender of the courier was not more than 100 rupees, particularly because on the face of the receipt the attention had been duly drawn that there were certain terms and conditions written on the back. It could be in the form of PTO, see back, please turn over, whatever may be the words used. And likewise, in case of dry cleaners, they have been generally limiting the liability to not more than 10 times the amount of dry cleaning charges. So, if, say, a person had given his wife's wedding lehenga, which might have cost them 4 lakhs of rupees, and the dry cleaning charges are 400 rupees. In the event of loss or damage to the lehenga, the customer cannot claim anything more than 10 times the dry cleaning charges. That is 400 into 10 equal to 4,000 rupees. So the entire loss, the wife might have used the lehenga only and only once during the wedding time. They will have to bear the loss. Dry cleaner cannot be held liable in case he had drawn the attention of the parties. Similarly, if attention of the parties had been drawn, the courts have held that even though the terms and conditions may be in a language foreign to the person, he will be bound. It becomes his duty on learning that there is something on the back to get those terms and conditions duly translated and only give his consent after approving those terms and conditions. You know, whenever you download an app, now you have to accept certain terms and conditions. Even though you may have the patience to run through all those terms and conditions, and you believe that some of those terms and conditions they actually invade on your privacy, and you are not inclined to therefore accept the same, so you may refuse. The app will refuse to be downloaded. That is the trick that these people play. Accept all the terms and conditions, give all the necessary permissions that the app is asking for if you want that app. Otherwise, you will not have the facility of using that app. I think I shall stop here because there are other issues relating to offer, of course, but we shall be taking them up in the next video. I am deliberately trying to keep my videos short on the basis of the feedback received that I should be keeping these videos short to increase the viewership. So I am limiting my videos to 15 minutes. I am trying to limit to 15 minutes, and I have been able to do that exactly for this particular video. It's just 15 minutes. Thank you very much for watching this video. We shall continue with certain other aspects on law relating to contracts in India in this series of lectures to follow. Thank you.